Good morning. This is Gary DeWaal for Bridging the Week for December 14th to 18th, and today is December 21st, 2015. The Commodity Futures Trading Commission issued a host of year-end final and proposed rules, including a final rule on uncleared margin for swaps and proposed rules aimed at enhancing cybersecurity at designated contract markets, swap execution facilities, derivatives clearing organizations, and swap data repositories. Separately, CME Group and ICE Futures US publicized multiple disciplinary actions touching upon a myriad of alleged rule violations. We have a potpourri of matters this week to cover in the last edition of Bridging the Week in 2015, so let's get started. Chicago Mercantile Exchange Group Exchanges and ICE Futures US brought, and in all but one case, voluntarily settled disciplinary actions charging a myriad of alleged rule violations from improper exchange for related position transactions, unpermitted pre-hedging of block trades, a position limit violation, wash sales, and various other trade practice violations. As an example, the Chicago Mercantile Exchange charged 5 firms in 7 disciplinary actions with engaging in so-called transitory EFRP transactions involving foreign exchange products. CME claimed that none of the firm's transactions included documentation of the corresponding cash positions and thus were not bona fide. Fines for the 7 disciplinary actions, which were all voluntarily settled, range from $7,500 to $60,000 US. Similarly, the New York Mercantile Exchange charged 4 firms with engaging in EFRP transactions without a transfer of ownership of the cash commodity underlying the exchange contract, a related product, or an over-the-counter instrument. To resolve these matters, the firms agreed to pay fines from $15,000 to $30,000 US. And finally, 2 firms were charged by CME Group Exchanges with pre-hedging block trades after receiving solicitation for such trades, but before consummation. As a result, claimed the exchanges, the firms were able to lock in profits. To resolve these matters, each firm agreed to disgorge its profit on the relevant transaction and pay a separate fine. There's a lot more to know about these disciplinary actions, including advice on EFRPs and block trades. Check out the article version of Bridging the Week on the website. The Commodity Futures Trading Commission approved final rules for uncleared swaps for swap dealers and major swap participants. In general, in connection with each swap transaction, the rule requires the two-way posting and collection of initial margin by swap dealers and major swap participants that are not subject to oversight by prudential regulators in swap transactions with registered swap dealer or major swap participants and certain enumerated financial end users with so-called material swaps exposure. Initial margin will not be required for swap transactions between covered swap entities and commercial end users. Variation margin requirements will differ depending on the types of counterparties. The receiving party must segregate mandatory initial margin with a custodian that is not an affiliate. The CFTC rules generally follow rules recently adopted by U.S. prudential regulators, with one major exception. Swaps between affiliated entities may not be subject to initial margin requirements under prescribed circumstances. One CFTC commissioner, Sharon Bowen, did not like this difference and expressed her views in a dissenting statement. The U.S. trial court handling enforcement action by the Commodity Futures Trading Commission against Kraft Foods Group and Mondelez Global over Kraft's alleged manipulation of wheat futures contracts in 2011 denied Kraft's June 2015 motion to dismiss 2 counts of the case. The CFTC claimed in its initial enforcement action that wheat trades Kraft entered into for the alleged purpose of hedging were in fact entered for the purpose of artificially lowering prices in the related cash market. This activity, claimed the CFTC, was a violation of federal law and Commission rules. Kraft had sought to dismiss 1 count of the Commission's complaint that relied on the CFTC's recently gotten anti-manipulative or deceptive device or contrivance authority under Dodd-Frank, claiming, quote, at its core, the CFTC's complaint accuses the firm of fraud and manipulation for seeking to purchase wheat at the best price it could in the face of difficult market conditions, end of quote. Additionally, Kraft said that the Commission's claim under its traditional manipulative authority should also be dismissed because the CFTC failed to plead that the firm's conduct caused an artificial price and they had the requisite specific intent. The court denied crass motion. The Commodity Futures Commission and the Securities and Exchange Commission both filed and settled an enforcement action naming J.P. Morgan Chase Bank over the bank's alleged failure to notify clients of its wealth management business of its preference, because of economic incentives, to invest client funds in certain commodity pools, hedge funds, and mutual funds managed and operated by an affiliate or in similar third-party managed vehicles that provided payments to J.P. Morgan. The SEC action also named J.P. Morgan Securities in connection with similar conduct for non-wealth management clients. J.P. Morgan resolved both actions by agreeing to pay an aggregate fine of $167.5 million US, disgorgement of $127.5 million US, and almost $12 million US in prejudgment interest. The two agencies claim that J.P. Morgan's alleged wrongful conduct, which constituted a conflict of interest, occurred from at least 2008 through January 2014 in connection with the proprietary funds, and from at least 2008 to August 2015 in connection with third-party entities. And finally, the Commodity Futures Trading Commission proposed rules aimed to enhance cybersecurity at designated contract markets, swap execution facilities, derivatives clearing organizations, and swap data repositories. All such entities would be required to conduct 5 types of testing consistent with best practices on an ongoing basis, subject to minimum frequencies: vulnerability testing, penetration testing, control testing, security incident testing, and enterprise technology testing. The CFTC will accept comments to its proposed new rules through 60 days following their publication in the Federal Register. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. This is Gary DeWaal. Have a great week, and until next year, ciao and happy holidays.